Judge Casanueva,
Yes.
we just need Attorney Reimer to turn on her camera and microphone.
How do we do that?
All
They've heard the sound of your voice. And we have Attorney Reimer here as well. So we have everyone together. Again, what was that show for the first time or whatever? Mr. Warren, I believe you represent the appellant in this case. Is that accurate?
Yes, sir.
And did you wish to reserve any time for rebuttal?
Yes, Judge Castanueva, may I reserve 5 minutes?
Absolutely. I will try to find an appropriate moment, pardon me, to let you know when you arrive at that destination or just beforehand and not try to break up your thought or your response. So I'll do my best. That's about all I can promise you. With that, we are prepared to begin. Floor is yours, counsel.
May it please the court, I'm Michael Warren, and I am here on behalf of the father appellant. In this case, there are two different types of issues. They're both very meaningful to my client. One is a mathematical de novo review issue based on a perfected record. And the other issue is very different. It's about time sharing. It's an abuse of discretion standard. And while my client cares a great deal about that, it is a not insurmountable task on appeal, but a harder task on appeal. And I'd like to focus first on the mathematical, the de novo review.
As you do that, counsel, would you tell me if on page 8 of the final judgment, in I guess paragraph dealing with child support, the court seems to impute income?
The court imputed income for the year 2023 without making requisite findings.
Well, the burden of persuasion for that would be upon the mother, is that correct?
Yes, Your Honor.
And the case law requires particularized findings to show a number of things, and none of those seem to be present in this order. The reason I ask is after reading the record, the first time I found an imputation of income discussion was in summation. Did I miss it earlier?
No, Your Honor. And there are...
So will that be included in your first issue?
Yes, that's going to be the mathematical side of the case. Now, the most interesting side of the mathematical side is simply an erroneous interpretation of determining gross income, which is just a legal determination. What is income? How do you determine what is income under 6130 Florida statutes? Here, the mother made an argument at trial that the income that was listed on my client's financial affidavit on line 1, which was all his income, should also be counted on line 13. Line 13 is for...
Well, the other confusing matter on that is you have 1099s for at least 2 of the years, 21 and 22, right?
Correct.
I think you have a tax return from 21 also, right?
Correct.
But the 1099 is a statement of gross income, correct?
Correct.
It's the top. There's nothing
It's as
beyond that.
it's as high as you can get unless there's additional testimony or additional 1099.
But yet, yeah, of income from other sources.
Correct.
Which this in-kind stuff came out of the 1099 source. Correct?
Judge Morris, you're all over it. Absolutely.
Okay. So the maximum that could be awarded in 21 and 22 for sure is the 1099 income. And yet the court on both of those years substantially exceeded the 1099 income, correct?
Precisely.
So 2023 was the imputed income, right?
That's right.
Okay. And remind me, was there a 1099 for that year also?
No, that I don't. I know that the taxes were not completed for 20.
I believe
right.
the husband testified he had the records but had not given them to the tax people. And so the trial judge also prohibited him from testifying to certain aspects of that. But I'm not sure that was raised. But yeah, I don't think his last year, because he sold the business, we had a 1099.
But the bottom line is that the 2023 year imputed income that far exceeded the maximum he ever made in 21 and 22 as supported by the 1099s, correct?
Absolutely. And you can't
Okay.
impute income higher than what a litigant has ever earned previously.
Yeah.
There's just no
Okay.
evidence that this guy ever made that amount of money.
Okay, those are all my questions.
I just had one follow-up. Didn't the court reject the father's argument by saying he can't pay all these expenses and only earn 60,000 a year?
I'm not in the mind of the trial court judge. It is possible that the trial court judge heard the testimony and thought, I don't believe that guy. And I think there might be something else out there.
Although
But-
the judge, I think, went off on in-kind contributions.
It did. But the point of an appeal, obviously, is that we got to look at the record. And there's no evidence in the record of any additional money above and beyond the 1099s.
Okay. Was Uber reported, and was it Uber income included in the 1099?
Justin, if you'll repeat that question one more
I'm
time.
sorry, was Uber part of the 1099? Uber income?
Uber is its own lesser issue. The client made $674, I believe, in Uber and ride sharing, and by way of, I believe it's a scrivener's error. It wound up in the final judgment is 10 times that amount, and that was brought to the attention of the trial court. That error appearing for the first time in the face of the judgment through a motion for rehearing, and that is before the court as well. I think Judge Morris has it right. We got to look at what is the maximum level here of income, and we have to say that's our starting point. And to answer Judge Casanueva's question about deductions that were not given, as appellate counsel, I'm limited to all the same stipulations that trial counsel made. And trial counsel, I think in a moment of frustration, stipulated to the trial court and said, let's just forget about taking deductions from that 2022 income, and let's just say the 1099. And so that's a stipulation that was made at the trial court level, and I'm bound to it here. I do believe that the father was entitled to some business deductions, as he was granted full business deductions in 2021, which is what lowered his income down to $27,000 or so. And then in 2022, he operates the exact same business. He receives no business deductions whatsoever. So
But you're looking for a reversal and a remand for a new trial on the income issue? Or is there enough in the record where we can determine the actual amount?
I'm asking for this court to determine the rights of the parties based on the record that it has. And it has a full record of a full trial. The mother testified at this trial. She never said a word about his income. We have a record where this court can say, this is his income from 2021. This is his income from 2023. And I think the court should issue a finding that that we should have a remand on his future prospective income, but it should be no higher. If there's an imputation, it should be no higher than the maximum amount he ever earned. With respect to the other issue on appeal, the other type of issue on appeal, my client is a loving father. The record supports that. He had 50-50 time sharing with the minor children up into the date of the final judgment. There's some discrepancy in the record on that, but it's undisputed. But 12 months before, at least 12 months before, it was 50-50. Going up to trial at the very last moment, the mother filed a child support guideline and asked for a parenting plan and asked for 60-40, 60% time. The judge found, after hearing all the evidence, for 67%. So the judge went above and beyond what the mother had requested. And I'm not suggesting that that is per se unlawful or an error. I think that there are cases, and I've been involved in a case where, unfortunately, neither parent wanted full custody and time sharing of the child. And so there are times a trial court judge has to take all the evidence and make a best interest of the child finding. And not everyone's going to be happy with it. But the issue here, the legal issue here, is that the record is devoid. The record is missing what you would need to have to support an unequal time sharing plan. And the couple things, there are only two things that the trial court judge mentioned in her final judgment as to why were having an unequal timesharing plan. One was that the father deferred to the mother. The mother is a nurse practitioner by trade. The trial court criticized the father, saying that you're deferring too much to the mother in the areas of the doctor's appointments for the child. I don't think that that should count against the father, and I don't think that there's been any showing connecting that grievance to a detriment to the child. The second one, remember there are only two. The second one is that the father apparently unwisely spent his money and he didn't have enough money to afford soccer practice and ballet. And the issue with that one is that if you look at the record's clear that the objection to these activities was not based on finances. It was based on the age of the child. The child at the time was 2. And I know lots of parents within reason might say, well, that's just too young for soccer or ballet. And so I don't think that we have support in the record to justify the trial court's, and this is an abuse of discretion standard. So we're looking at whether this is unreasonable, fanciful, arbitrary. I think the record has to support the judgment of the court, and it is lacking at this point for not only child support, where my client is now left with this judgment he can't near afford, but also he's been deprived of 50-50 timesharing without proper support in the record. And if there are no questions, I'll await my rebuttal.
Okay, very well, counsel. Thank you. Thank you for your patience. Attorney Reimer, you may proceed.
Good afternoon, everyone. May it please the court. My name is Angela Reimer, and I represent the appellee mother in this particular case. And I am going to cut to the chase and jump to the numbers that counsel and you all discussed a moment ago. I don't disagree entirely with counsel's argument, but I believe there is a component to this that we are all overlooking, and perhaps the judge did not say it the best way possible or explain it the best way possible, but talking about the in-kind income. So what the court was given and what the court looked at were a series of documents relative to the year 2021. Okay, we had financial affidavit that was originally filed. There was a tax return which included Schedule C for business income, and then there were 1099s and bank statements. And it appears as though that's what the court used to create this what was called in-kind income application after reviewing the documentation. When we look at the financial affidavit, the father's gross income, which would be his personal gross income, was stated to be $2,860 per month. He then has personal expenses of $4,871 per month, which gives a negative $2,201. Now, when you look at the bank statements, he's not in the negative. That's the first thing. The second thing is that this was...
Excuse me, counsel. I mean, one of the problems I see immediately with that is his $28,000 was actually his net income from the proceeds of his insurance business. So his insurance business, the 1099 of whatever it was, I think I have it here somewhere, $58,638.03. That was the gross income from his insurance business. And then with all the deductions, his net income was $28,000. And while that would ordinarily be a gross income to a regular employee, because he's a sole proprietor and sole ownership of this LLC, it's really his net number, not his gross numbers. So his bank statements aren't going to line up with that. They're going to line up with the gross number.
Well, and you are correct, but here's the thing. The bank statement, well, the bank account that the father used. He maintained one account. It was business and personal. So all expenses flowed from this one account. All income into this account and all income out of this account. And what I believe the court was explaining here is that on the financial affidavit, he's submitting to the court that, I'm sorry, did you have a question?
Just a call. You had a call.
Okay, okay. So what he was submitting to the court was that his income for purposes of child support calculation, which would be his personal gross, was the $2,860 per month, $2,860 per month. However, when you look at all of the financial information, and what the court said was the trial court believed that some of the expenses that were taken off before you get to the personal income were not actually business expenses, but were rather personal expenses. Therefore, while we're dealing with one big bucket, it's where the line was drawn for purposes of the court's calculation that the
But she added it, but the court added it back in on top of the 1099 income.
It appears that it was added in above the financial affidavit income. However, in doing so, it did exceed the 1099 income.
Well,
And-
I mean, you can't get blood out of a turnip, you know? I mean, how do you do that? There's
Well,
no way to justify that.
And that's where I said I don't disagree with what counsel is saying, but I'm trying to look at the entire financial picture to justify it in my head as to how it was rationally determined what the numbers were. And what it appears that the trial court was looking at were the expenses that the father said he had every month. In order to cover those expenses, be it business or personal, whichever bucket you put those expenses in, the income had to be higher. And if
I mean, and below the attorneys in the trial court, the father's attorney there stipulated to his 1099 income. Based on everything I've read, I'd take that money and run. I mean, that's a pretty fair situation. I don't know how you can improve on the 1099 income. That's your ceiling.
I agree, Your Honor. The other thing with that, though, that I think is worthy of consideration is that throughout the years 21 through 23, so there's two 1099s that were provided for 2 years. There's the 2021, I believe it was Gooseneck Insurance, which was his insurance business. And then there was a 1099 for Uber. And that was for both 2021 and 2022. Now, what you see when you look at all of the records is that the numbers used for purposes of financial affidavit, the bank statements as far as deposits go, and those particular documents, the numbers all vary slightly. And what we see is that in 2022 and in 2023, there's not only Uber income, which was testified to, but there's also Lyft income and something else that suggests it could be another ride-sharing deposit into the bank account. Now, none of these things were disclosed during the trial whatsoever.
They're pretty insignificant amounts, though.
The
small
Uber
amounts of
income
money.
is not substantial, Your Honor. And I think it just goes more to the overall lack of information and the trial court working to piece together what.
And I respect that if we were talking about trying to find out what his net is after expenses. But we're talking about the 1099 income, the absolute ceiling.
Correct. And the 1099 income, and I certainly understand that income, even for 2021, was of course higher than what was presented. And that's where the judge's calculation began. So I think that is what we would submit to the court, that the judge the judge was trying to evaluate all evidence that was available and trying to reconcile how the father's expenses were substantially higher than would have been justified by the number that he presented, which was the $26,000 was the original personal income amount on the financial affidavit. Now, with respect to the imputation of income, which came for the year 2023, the couple of things with that is that the father began working a W-9 position, W-2 position, and testified that he sold his insurance business. There was no information provided as to what the purchase price was, how it was paid, streams of payments that were coming into the bank account. None of those things were explained by the father, but were presented as evidence through the bank statement. And the father was working part-time, which put him making substantially less than he had made if you're looking at the 1099 income through the insurance agency. And I believe what the trial court tried to do was simply say, look, you have historically made more, and you have now taken a position where you're making substantially less on the eve of this trial.
Was there
And
any
the judge
testimony
tried-
that was there any testimony he had rejected more employment?
The testimony was that he was starting up with this company and was working to grow with the company and grow his income. That was what the testimony was.
Well, assuming the court rejected that, where's his support for the judge's ruling that he was capable of earning more money?
Simply put, what the ruling says and what it appears the judge did was take the income that had been determined for 21 and 22 and then use those figures to impute that for 2023.
No, I think I understood what the trial court did, but normally they don't do something without support for their logic. They just can't intuit the result, and that's what the judge did in this case, in my view.
Well, Your Honor, if I understand your question, and I may be missing it, but the judge stated that he was making substantially less than what he had earned in previous years, which does track in part with the statute regarding imputation of income. As far as specific testimony or other arguments through the case, there was not very much on that, although the father did testify about taking this new position, selling his insurance business, and that he was looking to grow with this company and would increase his income at that point. And what the
I
judge...
think Judge Vellante is driving at is the party that bears the responsibility of providing evidence for imputation. In this case, is the mother, because she is the one seeking. And we have written as recently as Zarillo at 343 Southern 3rd, the court's imputation of full-time income did not include any findings as to the current employment market in the community or that there were any jobs available to him. That omission is error. You know, in case Thomason versus Malicki, you have to have competent, substantial evidence to support imputation of income. And I think that's what Judge Vellante is driving at, because there's even a Judge Vellante opinion I have in my stack as well. You just don't get to make a leap based on an inference. There has to be a bridge of proof. And we're wondering is what proof did the trial court have before her? And what evidence did the mother present to the trial court to sustain their burden of persuasion? And if the answer is none, then we know it's error.
Your Honor, I believe that the evidence was elicited through the father's testimony, not through the mother's testimony. And
the father's testimony was the insurance industry was failing for him. He wasn't getting as much on premiums, and this job provided an opportunity. As Judge Vellante asked, if assuming the trial court is going to disregard that testimony and not find it credible, what evidence does what evidence does the mother rely upon to sustain her burden of persuasion? If he's the only one who testified, and that's all he said. I'm concerned that in closing argument, counsel for the mother led the trial court into error by saying impute income by not proving it, not meeting the legal requirements that one needs.
The only other testimony, Your Honor, that I am aware of from the father with respect to his current position was that he works as many hours as this employer would give him. That he could work more hours, but the hours aren't there, which goes back to this is a growing business, et cetera, et cetera. So, Your Honor, what I believe that is the evidence that would show he is not working to his full capacity. He can work more hours than he is allowed to work through this business.
And based on this record, where would he work?
Your Honor, I do not have the answer to that question.
You are correct, and neither did the trial court. And that's the point I think that Judge Valenti was driving it, and I was riding with Judge Valenti all the way. And you are looking at 3-judge panel who used to do this at the circuit level.
Absolutely, Your Honor. And I have stated everything that I believe was in the record, and I do believe that part was not there. If I then may, let me move on to address the time sharing issue. And with respect to the time sharing, the trial court.
Don't you agree it's a little odd for a judge to award something that wasn't asked?
Well, I've seen it happen before, and I certainly understand that. I believe with respect to the family law arena, I do see that the courts interpret the evidence and rule sometimes, I think, beyond perhaps what the party specifically asked for. But at the same time, my understanding of the trial court's job is to be the finder of fact, determine the best interest of the child, if that's the appropriate setting, and to make certain rulings based upon the evidence.
But I didn't see any findings about the best interest of the child. Did I miss them?
With respect to the time sharing?
Yes. Did she make specific findings? It's the best interest of the child for this or that or this or that? I didn't see that.
Well, in her order, in the final judgment at page, I believe it starts at page 2, the court had put into play a parenting plan, which did provide for the 67% overnight, which was a little bit more than the mother had requested. And what the court—
And the mother also testified very favorably as to the father. Really, all the testimony I read was like he was a pretty good father. He didn't go to medical appointments much. And, you know, I mean, this is irrelevant, but my wife's a nurse practitioner too. And my family, she takes care of all the medical stuff. I take care of all the legal stuff. That's just how we divide the labor. So it didn't shock me when I read that he said she should take them because she knows more.
Correct. And I believe the mother also took the child to the extracurricular activities. And I believe there was testimony as far as her schedule being more flexible, or she was more flexible to move her schedule.
What's the standard of review? The standard review is abuse of discretion, correct? On
Absolutely.
that issue. The other one might be considered de novo, like your opponent argued, but abuse of discretion is hard to overturn a trial court's discretion in this instance, for example. I'm sure your opponent will have something to say, but you have a nurse practitioner who was given things that father didn't dispute her qualifications to be a greater custodian. I guess the question becomes, why did the trial court give her more than what she asked for time sharing?
Your Honor,
even though it's a small amount.
Sure. And when you read through what the judgment says, where the judge goes through all of the factors relative to, the time sharing considerations, what the judge seemed to pick up on were the mother's history of taking the child to more appointments and more activities, right? So more more involvement with that portion of the child's life, and that doing a parenting plan that included the days in more sequence the way that the court did made it less cumbersome and less back and forth for the child trying to get with the one parent that was going to take the child to the different activities. And in reading through what the judge said was that the mother, consistently did what needed to be done for the child. The father perhaps prioritized his social life and vacations and even his grandmother, and going out, that sort of thing was what the court had actually put in the final judgment. But the way that I look at this is that it is upon the court, and what the cases say is that it is up to the trial judge to review the evidence and determine the parenting plan that is best suited for the child. The court is not just to arbitrarily select from the parenting plans presented by the parties, but rather create one or use from or whatever the court sees fit, but the court is not bound to use the parenting plan or the suggestions that the parties have given to the court if the court doesn't believe that those are in the child's best interest. And I believe that that's what the judge did in this particular case. The trial judge did go through each of the elements that the statute requires and stated whether or not that was favorable to this party versus the other party, and then of course included the factual specifics if it was relevant to the court's finding. And I believe that with the abuse of discretion standard, that given the judge's explanation as to what the judge felt was appropriate and important for each individual item, that we have to leave the judge's ruling as it is, because it is supported by what was taken as the evidence in the case.
Thank you.
So
Thank you, counsel. You hit it right on the numbers. We're at 1959. Did you want to sum up?
yes, very quickly. I believe that the time sharing, of course, I think should stand as is. With respect to the income issues, I believe that the income that was stated by the father for 2021 is most certainly understated, and that the trial court did what was expected, which was to evaluate the evidence and rule based upon the court's interpretation of the evidence that was presented.
Thank you, counsel. Let me clean. Well, I think we have a rebuttal argument. You are our last argument of the day today, Mr. Warren. So you have your 5 minutes and you may proceed.
Thank you. I'm going to try to read the tea leaves and spend most of my time on time sharing. I will wrap up at the end with a very specific request on what I'm asking, but on time sharing.
Well,
as
I have a
Judge
question.
said-
For my edification, are you seriously disputing the timeshare award? You want to make an argument on that the judge got that one wrong?
I do. My client cares a great deal about the time
No, I
sharing.
understand. We all care about this. But
And I think
you let off with the income being the most important thing because your
Yeah.
client really taking on a child who can't afford it, and the timeshare was less important. Do you want to elaborate on why the timeshare is more important than the impression I originally got?
well, it's more important to my client, his well-being, than the financial award aspect. The financial award aspect is cleaner.
Argue a case law, argue abuse of discretion, not the gut feeling, please.
My read of the case law, Your Honor, is that while a trial court has great discretion to review the evidence firsthand, to take credibility determinations of the witnesses, and that discretion is honored on appeal. It is not, the case law says it is not unbounded discretion. It must not be fanciful, arbitrary, or unreasonable.
No, we know all that, and I appreciate this. I know you probably do exclusively family law, and that's a great thing for a trial judge to have the benefit of. But where did the trial judge go wrong in this case by giving the mom more time sharing than the dad.
Because it's not in the best interest of the minor child. And the court's current conclusion of 67%, and I mentioned the party presentation doctrine in there, and a couple other issues I raised in an abundance of caution, but
Right.
the court, for whatever reason, went outside the bounds of what the parties were asking, and almost in a punitive way, doubled my client's income, and then gave the minor child considerably more 7% more overnights than the mother was even requesting. And the record as it currently exists, I don't believe supports the conclusion for unequal time sharing. I think if there's some logical justification, the court could say, wait a minute, we have to defer. We have to give that discretion to the lower court. But what they say in their findings of fact and conclusions of law either have to be there, or an appellate court can look at the whole record and sort of go, a tipsy coachman argument, is there other support in the record to get there? And as Judge Morris said, these folks were doing 50-50, and they, you read the testimony of the parents and you think, why is this at a final hearing? They were getting along well. And I submit to the court that request for 60% time sharing submitted, I think, 1 week before the trial, that was more about leverage and posturing for child support. Because as we know, that number is very connected to child support. The mother makes more money than the
Well,
father.
we don't know that. We don't know the motivation.
We don't know
the motivation. I mean, that's honestly outside the record, but a good try to make that argument, but I can't take that to heart, really.
Trial counsel tried to put that in the record as well, but it's hard to get in the minds of
Okay,
the mother.
I'm with you.
Well, I'll conclude with my request here. I asked that the court issue a written opinion. I asked that the court accept the business deductions that were in the 2021 final judgment. The lower court accepted those business deductions, and that was not an issue on appeal. That would put the father's income for 2021 at $27,097. I asked that the court reverse the income calculation for 2022 and put the father's income at $59,312.71. And that is, I simply added up the 1099s. I'm not asking for business deductions. And then for, I'd ask the court to overturn and strike income imputation and let the 2022 income simply be the last determination of what the income was. I don't believe a remand is required to discuss prospective child support. They had their trial, they showed up, they each made their arguments, and we have evidence in the record of $59,312.71. And then with respect to time sharing, I would ask that the court strike unequal time sharing, or at the very least remand, because there's not currently sufficient support to provide unequal time sharing in the record.
Thank you, counsel. Both counsels are doing exceptional, right on the numbers. Didn't have to say anything. I appreciate that. And with that, that will conclude today's session of the court, and I will allow you all to go. And we will shut down here, and we resume later on. We are in recess.
Thank you.
Thank you.